Yeah, welcome back to business taxation. The point where we stopped at last time was that we had found out corporation tax is for juridical persons, and that raised the question, what, by the way, is a juridical person, especially from the perspective of tax law. Now, questions which we have to deal with is, what are the requirements for a juridical person under civil law or company law? Which types of companies count as juridical persons under German law? What happens if an entity is not correctly registered or not registered at all? Is that possible that corporation tax applies or not? And if registration is not the fundamentally decisive point, what's then the difference to a partnership? Then, when only a juridical person can be taxed under corporation law, then the question naturally begins or shows up. When does the existence of a juridical person begin for tax law, and when does it end? So if people prepare a juridical person and already act for it, is that then covered by corporation tax or still by income tax? All this must be decided. And then we also have a problem with foreign persons or foreign entities, because when there is something foreign, it probably doesn't have a clear denomination like company or GmbH or limited company or partnership. It might be that it has some strange denomination which we don't know, so that we have to decide on our own knowledge or from our own perspective, is this now a partnership, this strange foreign entity, or is it a corporation, so a juridical person? All these things have to be dealt with. Concerning the foreign juridical person, I can already remark that there is sometimes the statutory seat relevant for determining if a juridical person can be accepted as such, or the state of the place of effective management or a place of the administration. When you have an entity which has been registered by an EU state, then EU law requires you to regard EU juridical persons as existing under all circumstances. So if the statutory seat of the company is somewhere in the EU and it has been at that seat correctly registered, then you have to accept that in every other member state. So you can then even not requalify that thing into something else. So it's not possible to say, yes, I acknowledge that this foreign entity exists, but although the French say it is a corporation, for me it's a partnership. No, if it is a juridical person, you have to accept it as a juridical person. Especially simple is that in case of companies, because in several tax legislative acts of the EU, there is a non-comprehensive but a very vast list of legal types of juridical persons of other member states. So there you can already see the list which things are juridical persons in other countries. If you have the law of non-EU states, then doubts can remain, because there we don't have such a close list of juridical persons. And so if something very, very strange shows up, a legal form which we do not know here, then you have just to compare to which form it resembles more closely, to a partnership or to a juridical person. On all this, we have to form some ideas now. Let's begin with, what are the requirements for juridical persons under company law and civil law? Remember, a juridical person can only be created by a command of the law, because such an absurdity like we all are forced to do as if a person exists, which in reality does not physically exist. Such an absurdity can only command it with binding effect for everybody by law. So then you also need that command by law. So you need a law which says this specific legal form, for example, GmbH, has to be treated as a juridical person. In cases where such a command is not in that law, for example, an OHG is never treated or never called a juridical person under the rules of Foundation for an OHG. So then it's a partnership or something else, but not a juridical person. Good. That means you will have to learn juridical person types by heart, as you perhaps already did in the first semester when it came to general basics. The most frequent juridical persons in Germany are Gesellschaft mit beschränkter Haftung, GmbH, that is limited company, or Aktiengesellschaft, AG, which is a public limited company, buy shares, or SE, European Society, which is the European parallel to Aktiengesellschaft, so a corporation. On the other hand, it's convenient also to memorize which forms stand for partnerships, and so for several persons who act together and do not form a juridical person. Here the standard forms in the German law would be the OHG, that is in English general partnership, the KG, Kommanditgesellschaft, that would be in English a limited partnership. And a limited partnership, ladies and gentlemen, must be kept apart from a limited company. It's not the word limited which counts. The decisive thing is if it's a limited company, then it's a GmbH or AG in German law, and then it's a juridical person. Or if it's a limited partnership, then it is a partnership where some of the partners are not liable for the debts, so that there is a certain debt limitation, but it's not a juridical person if it's a KG. And the simple form of partnership under the German Civil Code, the Gesellschaft bürgerlichen Rechts, so the association or society or partnership under the BGB, or sometimes called simple partnership. Naturally, there is a third alternative which you can come across in a case or so, that it's simply not one person, not several persons, but it's simply a thing, or a multitude of things which you see together. For example, a factory is not a person, not a partnership, not a juridical person. A factory is simply a mass of things organized together, and they are owned by some person, either by a GmbH, or they are owned by a natural person, or they are owned by a partnership. But the factory in itself is never a taxpayer because it's not a person. An office, a headquarter, or a permanent establishment, so a place where an existing firm runs a second, usually second, office room or something else, or factory building. Yeah? Also, that is always a thing and not a person. Also, the denomination business stands for a thing and not for a person. Good. You remember that. Then a juridical person's existence only begins when it's registered, because only when there has been some binding legal act, the registration, only then you and me are forced by law to believe in the existence of that thing. You and me cannot just sit down and say, oh, let's imagine there is a juridical person called the ABC GmbH, and now everybody has to believe in that. No, that can only become effective if it has been confirmed by the state. So we can make a draft for statutes and so on, but only at the moment of registration the legal existence of that entity begins. And when the last point of the ink dries, where the judge or whoever does it signed the registration document for that juridical person, then it exists. So that is the moment of birth of that juridical person, nothing else. The registration will be made in the state where that company or juridical person is established, where it's founded. So if you want to establish a juridical person here in Germany, then you can only select between the forms of German law, because a German legal authority, or let's say a German court, which administers the commercial register, is not able to practice French or English law. They have no legal ability to do that. So if your seat, so the official address of the institution which you are going to establish, is chosen as a place in Germany, then that automatically means you narrow down your choice of legal forms to forms in Germany. In the other cases, you narrow it down. If you decide for an address, let's say in Paris, then you have to register in Paris, and that means you can only choose from French legal entity forms. Good. Well, EU law states in a directive which has been reformulated but which is older, in a directive from 2017, that a company can only be regarded as non-existing once when it has been registered under very, very specific circumstances. And so usually that directive forces every EU state, every person throughout the EU to assume that once a juridical person has been successfully registered in a member state, everyone has to assume that it is existent legally, and that remains unchanged until it's officially removed from that register. So it's impossible to disregard the legal existence of a company established in another member state of the EU for this reason. But 20 years ago or so, the European Court of Justice also began with a standing jurisdiction that no member state can say that the registration of a juridical person in another state can be regarded as abusive and therefore ignored. So this was the famous Centros decision of the European Court of Justice, but in principle they only decided a thing which is self-evident. If we make a treaty where we say each French or each Irish company has the right to freedom of establishment in Germany, we cannot afterwards say, and we decide which French or Irish companies exist, because then naturally, if you take that serious, you could play around with your treaty obligations and just say that if I don't like that foreign entity, then I deprive it of its freedom of establishment just by saying, hey, you are not a French company. Naturally, that can't work, and that is the reason why the European Court of Justice and EU law say, well, every European Union company which has been successfully registered somewhere in an EU state must be regarded as everyone in the EU as legally correctly existing. By the way, the same naturally applies to companies registered in one of the states of the European Economic Area, that is Liechtenstein, Iceland, and Norway, because the Treaty on the European Economic Area just takes over the complete business law or business legislation, including company law of the EU, for all these three member states of the EEA. So there the same rules apply, and with effect to these three countries, the same rules apply. So no difference there. Now, Let's take up again the question what happens with entities which are not correctly registered or not yet correctly registered. Civil law is very clear in that if a juridical person has not yet been registered, it does not yet exist. That is even very dangerous because there is again a European Union rule which says if persons act in the name, so on behalf of a juridical person which is not yet registered, then the acting persons are completely liable for every activity which they undertake in the name of that juridical person. So even if you are not the owner of that entity which you want to found, but only a small employee or the maintenance guy for the elevator or something, but completely unimportant, but you do something in the name of that company, you are fully responsible for all the debts and liabilities resulting from your activity in person. And that, ladies and gentlemen, should bring to your mind one single principle or warning. Never, never act for a juridical person until you have seen the registration document or until you have been convinced, yes, this is a company which already exists for years. Never, ever act as an employee for a juridical person in GmbH which is on the way to registration, because then you are personally liable. Only after the thing has been registered you can act for it. That principle is also followed throughout the whole EU. The reason is to be found in the same Company Law Directive of the EU 2017/1132 EU. That's the file number of that directive. The only way out is if the company later is correctly registered and then declares its willingness to take over the obligation, then you are out of liability again. But if not, you are fully liable, so very risky. According to due to the fact that the European Economic Area takes over the complete company law and business law of the EU states, the same principles again apply in the European Economic Area, so in Iceland, Liechtenstein, and Norway. That's civil law. Now let's think about tax law. Tax law sees, at least in Germany, the situation slightly bit different. We have here the general principle that tax law looks to reality and not only to formalities. Okay, can't overdo that, but in principle, we have the basic idea or conviction that substance, what really happens, should count more than form. So there is, for example, a general principle that transactions which are not valid under civil law nevertheless will be regarded as existing for tax law if the people involved in these transactions stick to them. Although they are not legally binding, they just regard them as valid. And as long as that is the case, one regards that as valid for taxation too. And probably a same principle underlies the treatment of companies which are not yet registered. The idea is if a juridical person is not yet registered, but the people acting treat it as existing. And nobody cares for the fact that the thing is not correctly registered, then tax law also sticks to that and regards the GmbH or AG, which is on the way to registration, as already existing. Yeah. The condition naturally here is that it is indeed later registered, so that there will be a juridical person in the end. If a juridical person never is successfully established, then one evidently thinks there was no serious intent to create it, and then It's not a mere formality that that the existence is still missing, but then there is a very serious fault. The juridical person never exists, and then we say evidently there was no serious intention to create it, such a thing. So you must establish it later. But tax law, and that's the important thing, is says if a juridical person gets in the end registered, then we don't care for the formalities. If the GmbH begins to act or people treat it as existing and act in its name before it exists, we accept that. So the tax existence of a GmbH can begin before its existence under civil law begins. There is naturally a time limit for that because you cannot act in the name of a juridical person which does not even have statutes or so, and a name which is only up to now a floating idea in someone's mind. You cannot regard that as existing. So only the formality of registration must be missing. So at least you would need statutes and a name. So all the important steps must be decided already. If you try to act in the name of a juridical person where you don't even have statutes and a contract which sets it up, then that would be not a juridical person, but then this is a mere partnership between several persons with the aim to generate a juridical person. So the tax existence of a juridical person can begin a bit earlier than in civil law. Okay, now let's look to the other end. When does a juridical person die? In civil law, things are again really clear. A juridical person ceases to exist, it dies when it's crossed out from the register, when it's eliminated, when the judge or whoever it does makes an entry. Today, the A GmbH has been eliminated from the register. So this is a kind of death certificate of the GmbH. In the moment when the last letter is written down of that entry, the juridical person falls down dead and is no longer existent. So it can have no rights anymore. It can take no obligations anymore. Nothing can happen anymore. For tax legislation, that is a bit inconvenient, ladies and gentlemen, because imagine now you have a tax audit, has been announced, and the auditors will probably detect some hidden profits and increase the tax burden. Now you run quickly to the registration authority and have the GmbH removed from the register, and then you say, now they can't assess my GmbH anymore, it's no longer existent, and we can now have a year-long debate about who can be made liable for the remaining fiscal obligations of that GmbH. The fiscal office will not know to whom it can write a tax notice. That's not practical. And so tax legislation in Germany draws a simple consequence. For tax law, a juridical person is regarded as still partially at least existing until all its obligations and relations with the fiscal authorities have been successfully terminated. So that means a tax notice which replaces an original assessment for the year 01 can still be addressed to that company by even if that company has already been eliminated from the register. For tax purposes, it is still regarded as existing, so the persons who take care of the liquidation of the company have then to hold back a bit of the money which otherwise the shareholders would get, and have to use that money to pay off the tax duties. Also, a tax notice on a refund can still be issued and addressed to the company, because for tax purposes the company is still regarded as existing until the last tax file of that company has been closed, everything has been dealt with. That makes life for the fiscal administration and for the people involved easier. If the company has not been liquidated, but if it has been merged into another company, then the situation would be a bit different, because in case of a merger, that is a kind of inheritance. Then at the moment where the merged company is eliminated from the register, all its rights and obligations automatically hop over to another juridical person usually. And so there are automatically no tax obligations of the merged company anymore, because they have all been shifted to the new company which arose from the merger. Yeah. Let's look again to the last question, or last part of questions. Juridical persons. What was the problem if it's a foreign juridical person? Let's think about that again. Well, we have with foreign juridical persons two logical problems. And naturally, we have simple solutions to that, otherwise life would be impossible. But here are the two logical problems. First, imagine here in Germany, there is such a strange idea: you are forced by law to do as if a certain thing is a person. Naturally, only law can force you to believe such a thing. And now in Germany, only German law can force you. Australian or US law can have no immediate effect in Germany, because in Germany only the German state has a saying in what is binding. So now Australian law or US law gives you the command that you have to imagine there is a person called Mega Hard Corporation. You know, Mega Hard, I couldn't call it Microsoft. So it's Mega Hard. Now, if US law says everybody has to do as if Mega Hard Corporation is a person, US law is not binding in Germany. So you can only end up with the result that the Mega Hard Corporation also has to be regarded by everyone in Germany as a person if German law builds a bridge. And if German law gives the command, everybody, if the USA say this is a person, then everybody in Germany has also to believe that. So we need a kind of command in German law, under which circumstances also Germans are forced to believe in what US law says on that entity. Good. And the most convenient solution, naturally, ladies and gentlemen, is that German law says, okay, if a foreign state says this is a juridical person, German law says believe them. So if the US legislation says Mega Hard Corporation is a person, believe it, also Germans and everyone in Germany is then forced to say this is a person. This is convenient. Everything else, for example, treating Mega Hard Corporation with thousands of shareholders as a partnership or so, that would be horrible and impractical. There is only one exception. Naturally, German law draws the emergency brake in cases where they have the impression, well, this is not really a genuine bona fide US corporation. Somebody uses US law, for example, to avoid German law. Or something else goes on which is rather fishy and suspicious. So we don't want to accept this specific foreign entity as a juridical person because we think it should have been established under different rules. Now, how shall one decide if US law is really fit to decide the case or not? That is where you have to form ideas upon. So the basic thing is German law accepts the US decision on what is a juridical person, or the Australian or Russian decision on what is a juridical person in all the cases where we say yes, it's reasonable that the US or the Russians make that decision. So if they have to do with the case and if they are the natural authority to decide if that entity should be a person or not. And the practical application is we just say the state where that foreign entity has its place of management, so where the core of its activity is, the most important point, where it really is active, where it is at home. This state has the natural power to decide if that should be a juridical person or a partnership or something strange. And so we look to the place of management state. And then we say, does this state say it is a juridical person or not? So we regard that as the competent state to decide the matter, and we follow its decision. If the foreign state where the place of management is says this is a juridical person, then we say yes, then German law says believe it. If the foreign state says it is not, then we say it is not. Now, naturally, it might happen that a foreign company shifts its place of management, let's say, to France, but it has a legal form, it has been registered in Australia. Then we would just say, okay, the French and not the Australians are competent to decide on the legal nature. And when the French then say, but we, the French, think a company which is active and has a place of management in France should be registered under French law, we do not accept the legitimacy of that Australian company. We treat it as non-existent. Then the Germans would also say, okay, then it's not legally existent, because under our perspective, France would be competent to decide the matter. Now, the same would apply if you or I open up a coffee shop here in the middle of a village somewhere in Germany and want to avoid German GmbH legislation and therefore register a juridical person somewhere in the Pacific, in a small island where nobody knows the legal rules and so on, where they are very, very liberal. Then Germany would say, where is the place of management of that coffee shop limited company? And they would say everything it does, administration, everything is in Germany. So here's the place of management. So it should be German law, which has to decide if it is a company or not. Now this has been registered in some Pacific island. They are not competent to decide the legal nature of that entity, so this is not legally existing. Okay, hear it and forget it. In most tax cases in your life, you will always be confronted with legal entities which are clearly defined and which are a parallel to a GmbH, an AG, or a parallel to a clear form of a partnership. So there will be no problem there. And some states also follow a different approach, far more simple. They say everything which has been legally registered somewhere in the earth, irrespective if they are connected to that country or not, everything which has been registered somewhere successfully is regarded as a juridical person. We don't do this, but there are some states which do it. And remember that for registered companies or institutions within the European Union, we are bound by the EU Treaty to accept the legal existence. So if you want to run a coffee shop with place of management here in Germany, you could, for example, register it in Ireland as an Irish limited company. Then Germany would have to accept the legal existence of that company, because although place of management and everything it does is only in Germany, under EU law we are obliged to accept the legal existence of every foreign juridical person of another EU state, naturally. Now, there is a second logical problem. If we say there is an entity which is defined under a foreign law, then we still have to find out, is it a partnership or is it a company? Now, with many legal forms, it's easy to decide. But there might be legal forms which we do not know in German or even in European legislation, so that it's very difficult to decide what it is. We have partnerships and we have corporations, but we sometimes have different forms of partnership and different forms of corporations with different rules. So there might be mixtures, or there might be legal forms where it's difficult to draw the line between them. So apart from the legal forms where the nature is very clear, there might be additional forms which we do not know. For example, imagine there might be a foreign, very, very foreign country where, apart from husband, wife, and children, there might be also rights or obligations which are held by an entity which is called the tribe. Or there might be legal ownership for something called the family, but not for the family members. Now, how should we deal with that? In that case, you would have to find out the rules. And now German law only knows natural persons and juridical persons, but nothing in between. So we would have to decide if that strange entity is a partnership of several persons, so that every partner is taxed with his or her share, or if that is an independent entity, a corporation. That is usually then done by just comparing all the characteristics which determine the legal existence of that foreign entity with the two extreme forms of partnership and corporation, and then we just have to decide what is more convincing, so to which that thing resembles most. So if somebody says, well, I have no rights in that house that is owned by our tribe. Well, who is the tribe? The tribe is formed by all of the members of the larger family. So every family member has a share in the tribe's property. No, the tribe is completely independent. So if we all die, the tribe keeps the property, and nobody can sell the property of the tribe or so. I don't know. So you would have to find out, does it resemble more a corporation or does it resemble a partnership? Yeah. There is still another problem with the legal existence. We have already talked about the possibility that a GmbH or AG is accepted for tax law even before its registration, if later it is registered. But there might be institutions or entities in economic reality which are never successfully registered, or where never a registration is even attempted. For example, private associations are usually juridical persons if they are registered, but many people have a small chess club or a carnivals club and they don't bother to register properly. So that would be a non-registered private association. And the question is then, how do we deal with that? Is that a partnership or is it something else? So there might be things which are not juridical persons under civil law, but in practice which function completely like a juridical person in practice. So the question would be, how should we treat them, as a partnership or as a juridical person? And the solution or the answer to that problem is naturally, well, we are tax people. So we look to reality and not to the formalities. If really everybody in economic life and the members of that strange entity treat it completely like a juridical person, then we should also treat it as a juridical person and tax it under corporation tax. A general principle, very often to be found in the Abgabenordnung, reality counts more than formalities. Section or paragraph 39, there is something like economic ownership. If someone has only the name of owner, but somebody else holds all the rights of ownership over the complete existence of an asset, then this is the real owner. Section 40. If a transaction is illegal or immoral, that does not count for taxation. We tax you on the grounds of that transaction which you made, because illegal people should not be treated better than others. You should not be able to avoid taxes with the argument, well, I made profit, but I made it in an illegal way, so you can't tax me, because legally that does not exist, what I did. That would be unfair. There are several other rules of that kind, and so it fits in to say, if in economic reality something functions really like a juridical person in all aspects, but is only not registered, then tax law will treat it as a juridical person. So it's a quasi-juridical person. We could call it this way. Now, how can you find such a thing in reality? And how could you distinguish that from a partnership? And the answer is simpler than you could ever imagine. Let's first look to an example of a quasi-juridical person in practice. A very important sort of quasi-juridical persons in Germany are the trade unions. I hope you know what a trade union is. A trade union is an association of workers and employees who associate each other and in common then negotiate with employers about wage increases, working conditions, and it's a trade union which represents them. It's a trade union which, if they are not satisfied with the wage offers from the employer, which then organize a strike also. So a strike is usually organized by a trade union. So now you know what a trade union is. And these trade unions in Germany, at least, have never been registered as a juridical person. That comes from tradition. They were originally illegal organizations because they incited the workers to breach their employment contracts. If you really look on that, under a formal aspect, you signed an employment contract that you are willing to work for the next 4 years for a given salary. And if 2 years later you say, I'm no longer satisfied with that, I want to get paid with a higher salary, then what you do is you breach that contract. So that was illegal. And so in the 19th century or so, a trade union was regarded as an illegal organization. They could not be registered. And so naturally, they just existed. Now, they cannot be seen as a partnership because they are not a partnership of all the members of a trade union. You can just visualize that to yourself if you imagine what happens when you enter or leave a trade union. When you enter a trade union, the trade union has property. They own some buildings and they have bank accounts where they save money to finance strikes from. When you enter a trade union, you don't need to buy and pay for your share in the common property. The common property of the trade union is property of the trade union. You become a member. You are a member. You don't have to buy a share according to the value of everything which the trade union owns already. If you leave, you leave. You don't get a compensation for your share, let's say 1/10 millionth part of everything they own. You don't get a share or compensation for the share in the common property when you leave. So evidently, when you go into that, you don't have to buy part of the common property. You don't get a compensation for the common property if you leave. So evidently, you have no personal ownership in a share of the property. And that is the decisive signal for an independent economic existence of that entity, because the individual members of that organization have no ownership rights in the common property anymore. And that signalizes that this thing is no longer a partnership, because as our example 2 shows to you, if you become a member in the KG, let's say it has 10,000 limited partners, and your share is only 100 euro, but then you still have a share, and you have a share which has a value. If you become a limited partner in that KG, you will never become that for free. You have to buy and pay for your percentage of the common property. So when you become a member, you have to pay. Either you have to buy the share of someone else, or you have to make a contribution, which is sufficient to gain your, let's say, 1% or 1,00001% of the common property. So there is a share of the common property which is still owned economically by you. And if you leave, then they still have to compensate you for the economic value of what you gave up, of your percentage or small percentage of a percentage of what you owned in the common property of the partnership. And that signalizes the difference between what is still a partnership and what is a quasi-juridical person. By the way, the standard forms of a partnership, so simple partnership, KG, OHG, are never, ever taxed under corporation tax law, because the small your share might be, you still own a share under the legal rules for partnerships. So a partnership can never be a juridical person. Well, good. So KG always means it's still the property of all the partners together, and everybody owns a certain defined percentage. That is sufficient to say this can not be a quasi-juridical person. You find this rule even defined in paragraph 3 of the KStG, the German Corporation Tax Act, which has a quasi-juridical person has to be assumed only in cases where it cannot be seen as a partnership anymore. So, and that there the decisive aspect is, as I told you just now, that the persons behind that entity can no longer have any economic ownership in a defined part of the common property, so that this property otherwise had no owner at all if you would not treat that this quasi-juridical person as an independent entity. Okay, that shall be enough again for this subchapter, and you see the next subchapter is going to be on limited and unlimited tax liability in case of corporation. Goodbye until we see each other again for this subchapter. Have a good rest of the day. Thank you for watching. Till the next time.